The court is calling the court is calling NIMAC number 762-965 State versus Isabella Renee Molina. Could I have parties announce?
Rick Pena for the state of Texas.
Renee Munoz on behalf of Ms. Molina.
All right, so the court's sound is not working on our end. So she can hear us, but we cannot hear her. Defense, is this your client?
Yes, Your Honor, Isabella Molina is in fact my client.
All right, any objection to us continuing even though we can't hear her?
None from the state.
All right, defense has filed a motion. They're asking that this case be dismissed because an indictment has not been, the state has not indicted this case in a timely manner under Code of Criminal Procedure 32.01.
Yes, Your Honor, that is correct. We're referencing 3201 in terms of the writ seeking dismissal, no indictment within 180 days. This matter, the NM 762-965 began with an arrest on April 29th, 2024. As of today's date, October 21st, 2025, no indictment has been rendered. This is a total of 540 days in excess of the 180 days as prescribed by statute. Therefore, the defense is requesting dismissal of said matter.
All right, state.
First,
Have you reviewed defense's motion?
I have.
Is there anything in the defense's motion with regards to time that is incorrect?
No, everything's correct in the defense's motion.
All right. Any argument from the state?
Just that this dismissal should be entered without prejudice.
All right, defense, your motion to dismiss will be granted.
Thank you, Your Honor. May my client be excused from?
Yes.
Thank you.
All right, Erin Marie LaFontaine. Hello. Good morning.
So Judge, we're here on a compliance hearing. There was a supplemental report sent in regards to Ms. LaFontaine's use of marijuana.
Mhm.
I do have some updates since last time.
Yes.
This has been sent in.
Okay.
She did obtain a compassionate use
Okay.
prescription. That prescription was obtained on October the 16th.
Mhm.
And it is valid for a year. September 13th, she did complete the drug offenders education program.
Okay.
So those are the updates as far as that's concerned. I did want to make the court aware that, as you can see, she, other than what was happening, and without that prescription, she was doing fine. She completed her VIPP. She went through the entire class for the intensive outpatient treatment with us, but we could not successfully discharge her because of the positive UA.
Okay.
There has not been any reported issues in regards to her non-contact order. She's still responsible and she knows that she has to do 200 community service hours.
All right.
Our recommendation at this point, Judge, is for us just to continue to monitor her. And we're just asking that she continues to do what she's supposed to do on probation.
All right. So I know sometimes people will say, oh, it's just marijuana, right? But in Texas, it's illegal.
Right.
And in Texas, if you use marijuana while on probation, it's a violation. And it's the same thing with alcohol. While you're on probation, you can't drink alcohol.
Mhm.
And those are the rules in Texas.
You're fine.
So what I can tell you is, number one, I appreciate the fact that you've obtained your, oh, what's going on?
They're just messing with the camera. That's supposed to the jurors.
See, I cannot,
We'll do it after.
he's just like, no, we can't show the people. But this is what I can tell you. Oh, they do that because we're probably going to have jurors come up and jurors are never shown on camera. So anyway, what I can tell you is
Yeah.
I appreciate the fact that you got a prescription. That's the only way you can use marijuana if you're on probation, if you actually have a medical prescription for it.
Yes, ma'am.
So remember, probation has informed me that that prescription is only valid for a specific amount of time.
Mhm.
So after that time, if there's going to be continued use, you'll need to get another prescription filled.
Yes.
Now, you are due to expire on November of 2026.
Yes, ma'am.
If all goes well and you're doing great things, probation can always present to me a request for early termination. Of course, I always get the input from the state on whether they agree with it or not. If
Right.
they don't agree with it, then we'll have a hearing about it, okay?
Okay.
All right, keep up with the good work, all right?
Thank you.
Thank you. All right, Yvonne Pettis. Yvonne Nicole Pettis.
Yes, I'm, Mr. Barron's and Kelly texted me as I was driving in today asking if I could appear for them. So I pulled the file and she's looking at it so I can at least tell you I confer. This is apparently the first indicted setting.
Mhm.
So I just told Bob I would show up.
All right. All right, this is being recalled for October 30th
Okay,
and Ms. Green needs to be here.
okay, thank you. Jen.
Once you sign the reset form, you excuse.
I will.
All right, is this going to be contested?
No, it's gonna be with explanation,
Sorry, what?
with explanations.
All right. Court is calling 2022 CR 7151, State of Texas versus, how do you pronounce your first name?
Well, then, ma'am,
All right, so they're spelling it different ways.
it's misspelled, but what's the CUAHUT?
All right. All right, State of Texas versus Cuauhtemoc Martinez. Could I have parties announced for the record?
Gary Craig for the defendant.
And are you Mr. Martinez?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Cuauhtemoc Martinez who was placed on deferred adjudication in 2022?
Yes, ma'am.
CR 7151 for the offense of possession of a controlled substance penalty group 1 gram to 4 grams on September 26, 2022 for a period of 3 years. Is that you?
That's correct, ma'am.
All right, state.
Megan Galloway for the record and violation of condition number 4 in Bexar County, Texas, the defendant Cuauhtemoc Martinez, aka Cuauhtemoc Martinez, did then and there fail to report to the supervision officer as directed for the months of November 2022 and December 2022 in violation of condition number 4.
How do you plead to that? True or not true?
It is true.
And we'll even abandon the remainders.
Any objection?
No, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
I understand, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Like, true, but can I explain?
Yeah, I mean, you have a chance to explain, but my question is, knowing that I could sentence you up to 10 years in the
Oh,
prison,
Yes, ma'am, I'm aware.
do you still wish to plead true to violation of
Yes, ma'am.
condition 4? Court will find violation of condition number 4 true. State, what are you requesting?
Your Honor, we're requesting that you grant the state's motion, enter an adjudication of guilt against the defendant, revoke his community supervision, and sentence him to 6 years. And the reason in the prison, and the reason that we're asking for that is because the defendant was last seen by the probation department in 2023 and has made no progress on his probation.
All right, and defense, what are you requesting?
Judge, we would request that he be continued on probation in the mental health unit. I think this is a major slip up by probation. Talking to Mr. Martinez, he is a 24-year veteran of the military. He has traumatic brain injury and PTSD as a result of combat injuries. He has memory losses. What he told me basically is he called probation, showed up, and they told him his probation officer didn't work there anymore, that they would contact him. He says he never got contacted back. That I think he has trouble comprehending and maybe his memory has memory issues and other things that affects his decision making because of his traumatic brain injury.
Any objection to the court reviewing the court summary?
No, nothing at all.
No judge.
All right, there's something that you wanted to say to the court? You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Cuauhtémoc Martínez.
All right, so this is what I want to tell you. Sometimes probation will make recommendations. Sometimes I follow them, sometimes I don't. But I'm going to read this to you because I want you to be able to address for me what's in this justification. It says the probationer last reported on May 10th, 2023, and absconded since. Little to no progress was made while supervised. While supervised, the probation did admit to the use of cocaine while on probation. The probationer reported cocaine was his drug of choice because he reported that works for me. A mental health evaluation was conducted on February 22nd of 2023. And it was recommended that probation have a psychological assessment completed with Center for Healthcare Services for DDRF consideration, followed by monitoring or supervision through the MIC Genesis placement. The probationer failed to complete further evaluations with Center for Healthcare Services on May 1st, 2023. So, explain, because it appears that you had appointments that they had set up for you and you didn't make them. Because they're saying they conducted an evaluation in February 2023. And then after that evaluation, they recommended more evaluations. In your next evaluation, let me see. Yes, they said that you failed to complete any other dates that they had for you for evaluations. So you had a date in May and you didn't show up. They say you last reported on May 10th.
Well, that's when he got the warrant, ma'am.
Okay.
And when I called about the warrant, Mr. Cisneros, my probation attendant goes, there's no need to contact me. There's no warrant. Or talk yourself in.
Well, I mean, yes, when there's a warrant,
Well, but
there's no, because if you come to the office, they're gonna,
no, I understand, but where I guess like my confusion is that's 5 months into my probation, May. And for them to say that I just stopped showing up.
but no, why didn't you report for any of your assessments? Like they scheduled it, you made the first one, then after that, you just left, you didn't show up for anything.
If I recall, this is person I spoke with, it was through Zoom. And I told her that I evaluate mental evaluations through Low Ridge and through the TRICARE system. I'm just confused right now. I don't know. Bottom line, it's
Well, no, take a deep breath because I'm trying to figure out what to do with your case. And I will tell you, and the state will tell you, and the defense will tell you. State recommends what they want to recommend, the defense recommend what they want to recommend. That I'm not on anybody's team. I'm just here to get information and try to do the appropriate thing in your case. So I'm trying to figure out, and I want you to take a deep breath, just relax, because I'm trying to figure out what happened and whether or not you should be revoked or continued. So what I'm reading is that you made some appointments and you didn't make others, even though when you left, they said, hey, this is your next appointment. This is the date. I'm trying to figure out why you didn't follow through. And that all happened before a warrant was issued.
I guess just denials of my mental condition on my part. But it is.
All right, any questions?
Just briefly. Okay, Mr. Martinez, so even though you have an explanation for why you didn't report, you're not disputing that you have not reported to probation. Is that correct?
I don't even know what else to.
Okay, well, you pled true that you didn't report to probation, correct?
That's correct. I did.
And so back when you were placed on probation, the address that you gave probation was 3423 Norman. Who lived at that residence?
That was my parents' home. It was given to me when they passed away.
Were you living there back in 2022?
Yes, and when I came to court, one of the conditions was because of my medical condition, Ms. Boyd had stated that they're supposed to contact me before they would show up. If I was there, I'm there. If I'm not, I'm not. So and that's just the way. I didn't. The one time assistant mentioned that hey, they showed up and you weren't there. I was like, well, we have a little workshop in the back, where I weld stuff. But they're more than welcome to walk to the back. I even told her like, the gate is dummy lock. But just to keep, for people just walking in, because I had a bunch of stuff that I
Okay,
work on. So
okay.
I told them they're more than welcome to just walk to the back where I do my work, where the
Okay.
shop.
And Ms. Cisneros, that was your probation officer?
She was our probation officer, but when I first got into the probation program, it was someone else. But when I called in the month of October, because I didn't receive a probation date, they were told the individual that was assigned to you doesn't work for the county anymore. So as soon as we appoint somebody to you, they will contact you and give you your first report date. The November passed, and I called and said, I'm still waiting. They're like, Mr. Martinez told you, then when you get assigned, they will call you and give you a report date.
Okay,
And this didn't happen until January.
okay. So I guess my question is, the Norman G. Street address, have you lived there
Yeah.
since 2022 up until now?
Yes,
Okay, so,
up until now, yeah.
okay,
Right.
until you were placed in Bear County Jail.
Correct.
Okay, and so I guess you're aware that probation said that they sent a letter to that address, or you?
I wasn't aware of that.
Okay, so you're saying you did not receive the letter from probation? Okay, but if they say that they sent a letter to that address, are you saying that's not true?
Well, I don't know, because it was my parents' home, and then my other siblings and stuff get mail there too, so, sometimes
Okay.
like they just show up and get mail, or I'll get the mail, it just depends of who got the mail at the time. I
Okay,
have no recollection of it.
so you're saying you just didn't receive the letter?
Correct.
Okay, and then are you aware that probation attempted to make contact with you at that address 4 times in 2023 before they issued a warrant for your arrest? Are you aware of that?
No,
Okay, and then regarding in 2023, when you did meet with your probation officer, at that time you admitted to using cocaine. Do you recall that?
well, that was one of the questions she had asked, yes.
Okay, and you were truthful with her and let her know.
Well, yes, correct.
Okay. And then you did have some other conditions of probation that you were supposed to comply with. So like, one of them was that you could report in person or virtual. And so you did explain that you did prior to 2023 meet on Zoom. Is that what you said?
On Zoom?
Okay. But you also were supposed to take a parenting class. Did you ever do that?
At the time of the parenting classes, we had the option to either be able to do it online or in person, but there's a waiting
Okay,
list. And I explained that to Mrs. Allen, there's a waiting list. And the same thing for, she had asked about the community service, and I was like, well, from what I was told, if I completed both classes, parenting and anger management, that they would waive the 100 hours community service.
correct.
But I would explain to her, like, there's a waiting list. And every time I would explain something to her, she made it seem like she was an understanding, but her, her demeanor, her facial expression, okay, Mr. Martinez.
Okay.
So it's just kind of one of those things where I'm like, okay, it is.
So did you ever get on the waiting list for the parenting class?
Well, you would go online and you would submit, I guess, like a request or whatever.
Sorry. Okay, and then you also were supposed to do a stress education class. Are you saying it was the same thing?
That was the anger management.
That was the anger management? Okay, so you're saying that there was a wait for both
For
of them?
both classes at the time, because it was, they were just doing Zoom
Okay,
and they weren't doing classroom portion.
okay, but as you stand here today, you've not completed those classes. Is that correct?
No, I haven't.
Okay,
No, I haven't.
thank you. We pass a witness.
Any further questions?
No further questions.
Probation and your recommendation?
Judge, according to the court summary, the recommendation is to have them do a mental health evaluation to be completed in custody and follows all of the recommendations. I would like to note to the court that this case expired September 25th, 2025. So court is going to move forward with its duration of probation. He will need to be extended.
All right, just one moment. Deputy Laura, there's a young child in here. Here's my problem, and I want you to know, my thoughts, right? I understand your mental health issue. And I'm taking in consideration that you're a veteran, and I honestly don't think the government does all they should for veterans. But nobody's seen you. And what I can tell you is the court granted you deferred adjudication. The state was silent on your application. But at the time, the state was recommending that your punishment be assessed at 2 years and that you be placed on community supervision for 2 years. So the fact that the state was recommending that tells me a little bit about the case. Even though I will tell you, if I read the facts of a case and the state hasn't proved their case beyond a reasonable doubt, then I would have found you not guilty. I just don't think you're a good candidate for probation. And the reason why is sort of everything has been tried. So this is what the court is going to do. And I'm taking everything that you said in consideration. I'm taking in the fact that it doesn't appear that you've committed any new offenses. You just have not completed anything or done anything. So the court is going to find violation of condition number 4 true. The court is going to find you guilty. The court will grant the motion. The court will sentence you to 2 years in the prison. The court will give you credit for any time served. There's to be no contact with Ruby Rosario. And the court will recommend the therapeutic community. Counsel, is there anything else?
Nothing further, Your Honor.
All right. Did you review the trial court certification of defendants' rights to appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. So here's the thing, when you're released from prison, if you can't find help with anything, just come back here and I'll pick up the phone and see what I can do. When you were placed on probation, I did limited conditions for you just to address the issues that you had and protect the community. That's why I was referring you to Center for Healthcare Services. And the reason for the parenting classes and not community service hours was because of children. And then I was allowing you to report by Zoom or in person, however you wanted it. And I know that during COVID and the pandemic and everything was shut down, that was one of the reasons why I had the field visits, because I wanted to make sure that if there's something you needed or if you were in crisis, they could address that. But I mean, they can't do it if they don't have any contact with you, okay? All right, thank you. James Garcia. Morning. All I see is circling the wagons. All right, let me see. All right, so where are we on discovery? This is, I think, the first setting for this case.
Yes, Judge, it recently got indicted. I'm filing a motion for a sanity evaluation and also for competency.
Okay,
The state and I had discussions about the discovery. I think it's in there, but apparently there was a bunch of stuff from other cases
Okay.
downloaded there, but I think the big issue is gonna be the sanity evaluation.
All right, Ms. Ferguson. All right, this is what we're gonna do. We're gonna recall this. And council, you'll need to file that motion.
Their fault today.
All right. All right, thank you. What I'll do is we're gonna recall this for December 8th and we'll see where we are.
Yes, Your Honor.
All right, so we're gonna bring you back on December 8th.
Okay.
And then are you on the robbery case as well?
I don't know. if I
In the
am, Judge.
PF case? Norma, if you can make sure he's placed on the robbery case as well. Oh, I'm sorry, I'm looking at a different case. That's Israel Gonzalez. I think he just has.
He
the
just
same
has,
case.
yeah.
All right, so December 8th. All right, thank you. So on the sanity one, I'll go ahead and sign it, but they're not gonna do it until they complete the competency.
Okay.
But this way you'll have it. And if you'll just let them know that they can't do the sanity until the competency, because otherwise they'll lose it.
I think it's probably gonna end up being an NGRI.
Okay. Thank you. Anyone else ready?
Yeah, page six one down. Down from you.
That's mine as well, Judge.
Robert Keonis?
Well, I've got Bremer is the one I'd signed up on.
Oh,
I've got
okay,
Quinones. I'm
Dreamer.
gonna approach on Quinones in this one.
All right, Dreamer. All right, today is jury trial date.
So, the last couple of settings, we've been waiting for some at-large cases that were filed. Reason he's in custody is because he got indicted yesterday. I know at least on, sexual assault, but I can't tell from looking at the printout I got whether or not it's also an ag kidnapping charge. Those are with the PIC unit. So I haven't seen any discovery on the case, but I'd like to see if we can, I guess if we're going to try any case, the big case is the one I'd rather try so we don't have redundancy of ever.
All right, have PICU come down, please. All right, and then we'll come back on him.
Thank you.
And you're ready on Keonis?
Yes, ma'am, I am.
Robert Keonis. All right, so we were here, this case had recently been indicted. Where are we under the discovery?
I conferred with the state. My client would like a jury trial.
All right. State, how long is this trial going to last? All right, Norma, can you set this before the new year for a jury trial? And I'll need an acknowledgement of discovery. All right, your jury trial is going to be December 9th. You're going to be barred over, dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you need to do a clothing exchange. If counsel, if there's an issue with the clothing exchange, let the court know.
I will, Judge.
All right. Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plead open to the court. Do you understand? All right, thank you.
Thank you, Judge.
Eric Simmons. Hello,
Morning, Judge.
long time no see.
I've been around. I don't know what everybody's saying that.
Yeah, I'm like, I haven't seen you. All right, where are we on discovery?
Judge, so this is the first setting. I will apologize. I haven't had a chance to really look at the discovery. I know some things have been available, but I haven't downloaded. It's the first setting. So right now I'm just asking for a reset. They have made an offer. I have conferred with the state. They have made an offer, but I would just like a reset to review the discovery with Mr. Simmons, come back to court.
All right, Ms. Ferguson, I need a 30-day reset. All right. So we're gonna come back on November 20th. That's gonna be your plea deadline date.
Yes, ma'am.
All right. Once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
Thank you. Joseph Rodriguez. So where are we on discovery?
Judge, I was just appointed, I think 2 weeks ago. I have not, I don't have all the discovery in my file. I'm not sure if it's been uploaded or not. I was gonna ask for at least a little bit of time to review things.
Okay, was the state able to tender an offer or no?
They were, but I can't really credibly give him
Oh, no,
my
no.
advice at this.
Okay.
Yeah.
All right, Ms. Ferguson, I need a 30-day reset. All right, November 20th will be your plea deadline date.
Okay.
Once you sign the reset form, you're excused.
Thank you.
All right, thank you. Thank you for dressing appropriately for court.
My mom watches you on YouTube. She loves you.
Yeah, okay, I don't know.
You're right there.
Where's his mom? Hi, Mom. All right, so we will see you all back then.
Thank you, Judge.
All righty, so what is the update on the evaluation?
On October 14th, Judge Rodriguez found the defendant to be competent. And the jail is going to, the people that do those things at the jail is going to try to determine whether or not he should go to the state hospital
Mhm,
or whether or not he will have some other form of restoration.
mhm.
But the judge said she was leaning towards sending him to the state hospital. But that ultimate decision as to how he's and where he's going to be restored hasn't been definitively decided.
All right, well, the law has changed. I'm gonna have to review that because usually depending if it's a violent offense, you're supposed to go to the state hospital, but I'm just following this. So what we're gonna do, Norma, recall this for December. Yep, she stepped out again. We're recalling you for December, and counsel, it's just to see if he's been sent to the state hospital. Just let the court know before this date. And we're gonna call you back on
She's back to.
December 9th.
December 9th. I think he is going to go to the state hospital, but the judge kind of left it open.
Okay.
So I didn't want to not tell you about leaving it
No, no,
open
no.
or how long it was going to take.
No, that's not a problem. And I will tell you, Mr. Coleman, the reason why I set these, even though I know that you've been found to be incompetent, I set these so that you don't get lost in the system. Because it's easy to get lost in the system when you're waiting for someone to come back with evaluation, especially before you're sent to the state hospital. So we'll be back on December 9th. And if they've sent you to the state hospital, what will end up happening is your attorney will let me know, and this date will be moved. Because once you go to the state hospital, there are evaluations that they have to do to determine if you've regained competency. And they'll usually set that up in 120 days. All right. All right, so we'll have you back on December 9th unless you've been sent to the state hospital. If they still have you at the jail, we'll have you brought back to, so we won't lose where you are in the system, okay?
Thank you so much.
All right, you're welcome. Thank you. All right, so sir, you need to make sure that you're on time for court next time, okay?
Oh, yes, sir.
So, where are we on discovery?
The state and I have been talking about the case. I'd like to get a plea bargain deadline. I pointed out the video for them to watch. But if we get a plea bargain deadline, I think we need to be able to resolve the case.
All right, and how much time are you asking for, counsel?
I'd ask for 30 days, Judge. I'm pretty backed up.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date. Yes. November 20th, counsel?
That's not things.
It should not be Thanksgiving week. Let me see. No, it's not. Thanksgiving is the following week. All
That works for me.
right, that will be your plea deadline date. Once you sign the reset form, you will be excused. Thank you for dressing appropriately for court.
Thank you, Judge.
And then Ms. Brown, we can't hear you, but I know you can hear us. So if you could answer in the chat box, there's something wrong with our system on this end. They've been trying to complete it. And just let me find the case. It's Robert Keonis,
No, hers is Jonathan Dreamer.
Jonathan Dreamer. Okay, Mr. Dreamer, if you'll come down. All right. Attorney Brown, on Dreamer, it's my understanding that there is a case that's in your unit. If you could just tell me where you are on the discovery on that. See, some people then take typing in school. Coming in handy now. You can't just peck the keys. You got to do the home row. Yes, I'm telling you. All right, so defense, are you the listed attorney on the new case?
I would assume, Judge, I'm put it on this other case.
All right, Ms. Ferguson, can you make sure that he's on the case? And the state is telling me he needs to be assigned because it's at large. All right, and so Mr. Mauer, she says she believes she has all of the discovery. But she just needs to have the attorney listed. So what we'll do is we'll recall this for November 20th as well to make sure you have all discovery.
Okay, that'll be the discovery deadline.
Yes.
All right.
Ms. Brown, are you able to, is that a good date for you? I know you're in PICU. See, her hands got off the home row keys. All right. So she said if she's not available, someone else will be. So Norma, set that for November 20th, and that everybody, that will just be a discovery date. And if you all are able to tender an offer at that time, please tender an offer at that time.
And so this is not on the trial docket anymore?
Well,
This will be a discovery?
no, that will stay on the trial docket.
Okay.
And then, Mr. Mauer, I'm assuming you don't want to go to trial on this case with that charge that is.
I love picking juries in this court, Judge. I picked 2 in 1 week.
Yes.
I'd like to limit it to 1. I think we'll resolve all the issues.
All right. So then we'll come back on November 20th. And does anybody have the cause number of the other case so I can put it in the system?
I can.
Mhm. All right. And what case, the 7-2 case, which one is that? Oh. So 88 Brown, the 2025 CR 013272 case. Is that the case? You put it in the chat for me. Thank you so much. All right, so we'll come back on November 20th on that as well, and I will see you all then.
All right, thank you. I'm gonna have them sign a setting form, Judge, because it's gonna try to meet.
All right, thank you. All right, thank you for zooming in. Rogelio Ibarra. All right, discovery, where are we?
I have received the discovery that we were requesting. I need to review it. We've just received an offer today though, Judge, and we do need some time to consider that as I review that additional discovery.
All right, I need an acknowledgement of discovery done. And how old are you?
18.
All right, Ms. Ferguson, I need a 30-day reset for plea deadline. All right, so you're going to come back on November 20th. At that time, you need to let me know whether or not you reached an agreement with the state. If you have not, your next court date is going to be a jury trial date, and the court will not accept any plea bargain agreements after that date without good cause. Otherwise, you have to plead open to the court. Do you understand?
Yes, ma'am.
All right, thank you for dressing appropriately for court. Just have a seat. Once you sign the reset form, you're excused. Julius Martinez, where are we on discovery?
Your Honor, I don't, just today I compared with the state, and I wasn't getting the video. I couldn't get the videos downloaded. I made sure that they were there. So I believe, I don't know if it's my end or not. So I'd like a chance. And then today they just gave me an offer. So I like to look at the videos. They're very important in this case. And so, in order for me to recommend to my client or make a recommendation on the client.
All right, Ms. Ferguson, if I can get a 30-day reset for a plea deadline date. All right, we'll have you back on November 20th.
Yes, ma'am.
And that will be your plea deadline date. Once you sign that, you're excused. Thank you for dressing appropriately for court. Have a seat. Your attorney will bring the form to you.
Thank you, Judge.
Thank you. You're welcome. Court is calling 2020-23 CR 10719 State versus April Rodriguez. Can I have parties announce?
Ray Lopez for the defense.
And are you April Rodriguez?
Yes, yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same April Rodriguez who was placed on deferred adjudication in 2023 CR 10719 for the offense of theft under $2,500 enhanced on February 12, 2024 for a period of 3 years? Is that you?
Yes, ma'am.
State?
In violation of condition number 2, on or about the 11th day of April 2024 in Bexar County, Texas, the defendant, April S. Rodriguez, did then and there illegally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
That's true.
In Bexar County, Texas, the defendant, April S. Rodriguez, did then and there fail to report to the supervision officer as directed for the months of February, April, and May of 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
And on or about the 10th day of October 2024 in Bexar County, Texas, the defendant, April S. Rodriguez, did then and there fail to submit to drug testing as directed by the supervision officer in violation of condition number 27.
How do you plead to that? True or not true?
We'll waive the rest, Your Honor.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violations 2, 4, and 27? Court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violations 2, 4, and 27?
Well, do I have an option?
Oh, you're going to plead not true, and then what will end up happening is we'll have a contested hearing.
No, ma'am.
So do you still wish to plead true to 2, 4, and 27?
Yes, I do.
Court will find 2, 4, and 27 true. Is there a proposed agreement?
There is not, Your Honor. The state had originally recommended DVRF, but it doesn't seem as if the defendant would like it, so we're asking for revocation, given that there's nothing else that we can do with her.
All right, and defense?
Your Honor, we're asking for the court to extend her probation and to give her lifetime recovery as a condition for probation. And I call her as a witness to testify about what's been going on with these violations.
Would the court like the court summary?
Any objections to the court reviewing court summary?
No objections, Judge.
All right, could you raise your right hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
April S. Rodriguez.
All right, you may proceed, defense.
Thank you, Your Honor. Ma'am, when you were not reporting, what was going on with you during that period of time?
I was physically sick. I didn't know what I was sick of, but throughout the times that I didn't report, either the day before, the day of, or the day after, if you would allow me to, I don't know, somehow get my medical records, you will see that I've been in either an urgent care and emergency room here in San Antonio, trying to figure out what was wrong with me. I didn't know what it was. I recently got my gallbladder removed, and I know that my pancreas isn't working at the time. Like, I have serious stomach issues. Anyhow, so that's what was going on. But everything happens for a reason. I do believe throughout that, when you gave me that MTR, I have been struggling to get off of methadone for 14 years, which I've been able to do throughout the time that I've been at the county. I mean, I don't know if it makes a difference, but I've been working just to keep my mind occupied. I just would like for you to be aware of the fact that even though I wasn't doing good, I was still reporting to the best of my ability. I would like for you to give me an opportunity to finish the rest of my term, if that's an option. And
Okay, ma'am. So what was the medical condition you were diagnosed with?
I had my gallbladder was removed. I don't know the proper terminology, but at the time my pancreas isn't working. I still have issues.
Okay, and what did you do on probation? You did some things on probation, right?
Yes, I did. I did my parenting, I did my domestic violence, and I recall you telling me that if I did my parenting, I didn't have to do my community service. I did my psych eval with the Center for Healthcare Services. I don't have the date in memory, but I believe that the only thing I had left, I don't know if drug court was mandated, because throughout that time I picked up a CPS case, which my kids are currently under the custody of CPS. So whenever I asked my caseworker for drug court, he said it wasn't on the table. So anyhow, I did my parenting, I did my domestic violence, and I did my psych eval. I did 2 of them actually, one with CPS and one with Center for Healthcare Services.
And Do you have any prospective job employments or sources of income, or how are you gonna support yourself if you are returned back to probation?
Well, I'll get a job. I don't have a warrant anymore. I had to have an ID, you know, that's something that I've been wanting to do for the longest time, but haven't been able to simply because at first I had a drug problem, second, I had a warrant, but that's not the case anymore.
Last one, Judge.
Just a few questions, Your Honor. Ms. Rodriguez, when did you realize you had this gallbladder issue that you needed to have it removed?
Well, at first, I really don't recall the date, but I didn't know what it was. I just know that I was really sick and they couldn't find out what was wrong with me until I had like a serious episode and they like removed it the next day. So that was like within those 3 months that I didn't report. And I did, however, keep in touch with my PO through emails and phone calls, but I didn't go in person.
So the MTR alleges that you didn't report in November and December of 2024, February, April, May of 2025. Like it was more than 3 months that you didn't report.
Right.
Is that accurate?
Yeah, it sounds like it is.
Okay, so it also, the court summary also reflects the different efforts that the probation office made to get you to report. Do you remember those efforts that they were making?
Yes, ma'am.
Okay. And do you remember an encounter in January of this year where they actually made a face-to-face contact with you and explained to you the importance of reporting after many failed, or not failed, but inadequate reporting, that they made a face-to-face contact with you and explained the importance of reporting, and you said that you would? Do you remember that?
Yes, I do.
Okay. Was it after that that your gallbladder was
No.
removed?
My gallbladder was removed within those 3 months, but
Before that?
yeah. Well,
Okay.
however, I didn't get right because now I have an issue with my pancreas, which is why well, anyhow, that's what was going on.
Okay. And during that time, you had some positive UAs for amphetamines. So were you still using?
Those positive amphetamines was at first. I took the time that I was in the hospital, which was like consistent to be able to not, it was easier for me to stay off of drugs than to get off of drugs. I don't know if that makes sense, but when I got out of the hospital, I wasn't on them anymore. So I didn't ever go back. I was just trying to get my stomach issues situated.
And so why did you refuse to go to DDRF when it was originally recommended?
I don't, DDR, well, because at the time right now, I'm appealing an eviction. I only have like, I don't know, 6 days before I lose my home, and I have to the end of the month before my kids get adopted out. So I would really like to work on that. And I can go wherever you want me to go, if I could possibly save my home and try to get my kids back.
Nothing further on.
All right,
Nothing further, Your Honor.
I have a question. Did you complete parenting classes?
Yes, ma'am, I have my certificate on my phone in banking.
Oh, so you didn't tell probation you completed parenting?
At the time when I was talking to her, I hadn't completed it. I took it.
Did you turn anything in showing that you completed parenting?
I just recently completed it, no ma'am.
All right. And then there's the positive UAs in March, April, and May. I just don't think you're a good candidate for probation. I go by what's before me, and you've been on probation since 2024, and you haven't done anything. Probation, what is the recommendation?
The recommendation on the court summary is referred to. I would like to point out that there were several instances where we tried to get Ms. Rodriguez to do the Center for Healthcare Services appointments. And 3 separate times there was failure to report to those for the mental health evaluation.
Okay. All right, thank you. All right, so Ms. Rodriguez, here's the thing. You can people can only help you if you reach out for the help. If you don't, after they've set appointments after appointment for you, there's nothing else for the court to do. The court is finding 2, 4, and 27 true. The court is going to grant the motion, find you guilty, and revoke. State, what are you requesting for time?
Your Honor, would ask for 18 months.
Defense, what are you requesting?
We'd have for minimum, Your Honor. 6 months.
All right, the court will sentence you to 18 months in the state jail felony. The court will give you credit for any time served. There's to be no unsupervised contact with minors and no residing in household with minors. And the court will request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you need to speak to an attorney. And I'm so sorry. There's also to be no contact with Walmart. And this was a part of her previous conditions. No contact with Walmart on Bandera Road. All right, good luck to you. You're welcome. All right, could I have somebody from the state? Court is calling 2025 CR 01127 State versus Michael Bruce Peterson. Can I have parties announced for the record?
Megan Galloway for the state.
Then Callahan defense.
All right, this hearing was scheduled at 9 a.m. It is now 10:58 a.m. The defendant did not make an appearance. Defense, have you had any contact with Mr.
Been letters, but they have not come back, so only by letter.
Mhm. All right, in just one second, the deputy is calling the name. Deputy Laura, did you make an announcement for Michael Bruce Peterson? And I'm sorry, what's the result? All right, state.
We're requesting a bond forfeiture, Your Honor.
All right, that will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge. Be excused.
Yes, thank you. Right. Good morning. Thank you for dressing appropriately for court. So the court has the acknowledgement of discovery. Was there an offer tendered?
No, Your Honor, state needs to contact the victim, which I plan to do this afternoon.
Okay. All right, Ms. Ferguson. I need this recalled in 3 weeks for an offer to be tendered. All right, we'll be back on November 12th. Once you sign the reset form, you are excused.
Thank you, Judge.
You're welcome. Court is calling 2025 CR 005370 State versus Adriana Ramos. Can I have parties announced?
Rick Pena for the state of Texas.
William Agostino for defense.
And are you Ms. Ramos? Probation, this is an application. Mr. Castillon, did you review all of the discovery with your attorney? I'm sorry, with your client, and have you received the discovery?
I have, Judge.
Court will find that the state is in compliance with discovering. Ms. Ramos, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are proceeding on the lesser included offense of misdemeanor assault causes bodily injury family member.
Any objection?
No, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
The state is proceeding on the lesser included offense of assault causing bodily injury to a family member as a Class A misdemeanor. Range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? The court could find you guilty and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine.
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has been able to assist me in her defense.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Ramos, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, yes, ma'am.
If you're not a U.S. citizen, by entering into this plea bargain agreement, you will be deported, denied naturalization, and re-entry into the states. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault causing bodily injury family member. There's a $1,500 fine. The state is recommending deferred adjudication. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am, I do.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated primary custodial parent?
Judge, I actually did not discuss that with her. I do believe that currently the children are not within her custody. But
Do you want to have a chance to discuss that with her?
Just so you know, affirmative finding of family violence means that you still have rights to possess your children, to see your children, but in regards to whether you get to be a sole managing or a joint managing conservator, those rights are affected. You still have rights to see your children, have your children. You're not going to be able to be a joint managing conservator.
Meaning I will be able to have custody of it.
That's not, you won't be able to make certain decisions as joint managing conservator if y'all were to go to court and there was a contested hearing over custody. You still have rights to see your children, you still have rights to possess your children and to care for your children. You still have certain duties, but you would not have the same rights to decide as to, if you already go into a hearing as to whether your children, are going to be Catholic or not. There's certain decisions you can't make regarding their religious, educational upbringing, certain medical decisions. If y'all were to go into a contested battle, now you can come to an agreement with your husband for other things, but if you were to have a hearing, you're not entitled because of the affirmative finding of family violence to be a joint managing conservator.
I understand.
Okay.
And is this just until I?
No, it is continues on even after your probation.
Well, never be able
To be a joint managing conservator, not unless it's by agreement.
Do you want to have time to discuss that? All right, we can go. Right. All right, we're back on the record. So, Ms. Ramos, do you understand the affirmative finding of family violence, what it means and the impact it could have on any civil matters as it relates to child custody? All right, knowing those things, you understand that to be the entirety of the plea?
Yes, ma'am.
All right, and knowing that, do you still wish to go forward with this plea?
Yes, ma'am.
Defense, is this the plea?
It is just.
State, is this the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motion?
No, no.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 100 hours of community service restitution, the BIPP course, the TAP evaluation, follow recommendations from the TAP evaluation, a MIC evaluation, follow those recommendations in parenting classes. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Sure.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, this time state is offers into evidence, State Exhibit 1 with all attachments.
No objection, Judge.
Thank you. And state, have you spoken with the complainant?
We've attempted, Your Honor.
Oh. Ms. Ramos, did you review the wavering consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
I do, Judge. At the time of this incident, Ms. Ramos was not on her medication. She does suffer from some mental health issues. She has since that time got back on her medication. She additionally has completed a 12-hour anger management course. She has also begun the BIP program and has attended 8 of those classes. We'd ask the court consider that and allow that to be credited towards her current probation. Additionally, she has been attending NAAA meetings. I believe she has approximately 40 meetings that she has made. And she also has proof of the attendance for not only the NAA, but also for the BIP classes. And she also has proof of that anger management course. She did also try to enroll in the parenting class. I know she has some issues with trying to enroll in that, but I believe that she is on a good step forward. I believe that she's, very willing to comply with probation, and she wants to get back on track. And I think she's done a good job at doing that.
All right, and how often are you going to NA or AA meetings?
I do it at least every day. I do it through Zoom, so I have to set up like a time to where I can just log in even when I'm at work and do that.
And what do you do for employment?
I work at Amazon. I'm in training to be a manager, but I'm a sales associate.
Okay.
And I would note, Judge, that she is indigent, and the fine was at $1,500. And I did not address this with the state, but we asked that you either consider lowering that fine amount or probating a portion or the entirety of that.
All right, and where are your children now?
I'm with my mother-in-law.
Okay. Because is Child Protective Services involved?
No, ma'am. Because when I got out, when I was incarcerated, she paid me a visit. The woman who was doing the
CPS investigation.
CPS investigation. So I got out and I tried to reach out to her. She said it had been closed. There was nothing she could do for me.
And typically, I believe the CPS will close out those investigations if they're with a protective parent. I think that's what the case was.
Well, see, here's my problem with her being a protective parent. And mind you, this is not in my jurisdiction, but from reading the police report, and I don't know if you well, I'm sure your attorney went over it with you, but this is what I find concerning about the placement of your children. It says that the complainant refused medical attention. And then it says MedCom stated that the complainant was high risk, whatever that means. And so they contacted Child Protective Services because he was high risk. You were going into custody. So I don't know if he is with your mother-in-law with the children or not, but what I'm telling you is, in this report, it says that he was high risk, whatever that may mean. So that may not be an appropriate placement for the children. That's all I'm saying. I have no control over that. So I'm just letting you know that's what's in the document. All right, this is what the court is going to do. There's a $1,500 fine that will be probated. You to continue with your BIPP course to complete that. You to continue with your NAA meetings at least one time per week. If you know that it takes you every day to go to NAA meetings to remain sober, then continue doing that. That's not going to stop me from perhaps terminating your probation early. Proof of employment within 30 days, no employment as a home healthcare provider or with minors, regular reporting by Zoom or in person, regular random UAs. And with your mental health, are you doing that through Center for Healthcare Services or somewhere else?
No, I do it on my own. I get health insurance through my job. So I get my medication because it's already like an established medication. I just get it refilled.
Okay, so you'll need to sign a release so that probation can make sure that you're continuing with that, okay?
Yes, ma'am.
So it's to be continued mental health treatment with private insurer. Field visits 1 time per month for 3 months. There's going to be 100 hours of community service restitution. I'm going to require parenting classes. Once you complete those classes, community service hours shall be deemed satisfied. There's an affirmative finding of family violence. And there's to be no contact with the complainant. Probation, is there anything else?
The length of the deferred, Your Honor?
Oh, I'm so sorry. Yeah. All right, how long do you think it'll take you to complete these items?
Those things, maybe 9 months, 8 months.
All right, I'll place her on deferred adjudication for 1 year. If she completes everything, the court will consider early termination.
Thank you, Judge.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
Yes, ma'am.
All right, we can go off the record. All right, the parties on Johnny Richard Gonzalez.
That's all of them for Mr. Gonzalez, Your Honor.
Megan Gallagher, what is it?
Oh, I haven't called it yet, but I appreciate everybody making an announcement. All
We actually
right.
did something ahead of time, you know.
All right, the court is calling 2025 CR 010295, State versus Johnny Richard Gonzalez. Can I have parties announced for the record?
Megan Galloway for the state.
Dave Scott Sullivan for Mr. Gonzalez.
And are you Johnny Richard Gonzalez?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Are there any applications in this case?
No, Your Honor. Full application for probation and for adjudication.
So there is an application?
For probation and deferred adjudication. An application, state does not agree to it, but we have not.
Well, did you all fill out an application?
I think I did. Oh, wait a minute. I forgot to fill out one of the forms, Your Honor.
All right.
I was running back and forth. I will get that form and have him fill it out.
Okay, sure, just have a seat and we'll take that up.
Thank you.
All right, who's here on Timothy Ray Ibarra? Hello. So what is the update on his evaluation?
We have an agreed incompetency set for Monday.
Set for Monday?
Yes, the 27th.
All right, so then when he goes down there, money, he needs to come up here. Otherwise, there's gonna end up being a warrant issue.
Okay, because he's here today.
Oh, where is he?
Timothy, stand up.
Okay. Well, he needs to come forward. Why was he late for court?
His mother had a black,
Right, come forward.
He called me and said that AAA was there fixing it, but I was in the middle of a plea in the 144th and I couldn't lift it up here to tell the court.
All right. Hello.
Hi.
Hi. All right, Ms. Ferguson. Reset this case, December.
I will not be in Texas in December,
When is your last day here?
November 7th.
All right. Let me see something here. And so you're gone the entire month of December?
I will be, I'm house sitting up in Maine.
Okay, for the entire month of December?
I'll be leaving shortly after Veterans Day and I'll be gone the entire year, rest of the year.
Okay. Norma, recall this for January 5th.
I come back on that.
That's why I'm asking. You're
Oh.
being very coy.
Oh, I'm
'Cause
sorry.
I'm trying to set a date. All right, when are you back?
The 9th.
All right, Norma, recall this for the 26th. Yes. All right, we'll bring you back on January 26th. Once you sign the reset form, you're excused. Okay?
Okay.
All right, thank you.
And if he's ordered to be incompetent, you still want him to be here?
Well, it depends on what the update is there. I don't know that he may have regained competency by then. I have no idea. All right, thank you. Just have a seat. Juan Rivas.
Present, Your Honor. Morning, Judge.
Hello. Michael DeLeon.
Judge, I believe this is a discovery setting.
Final discovery setting.
And even though it's a final discovery setting, I've been going into the discovery of this particular case and made the state aware that there are school records that are going to need to be subpoenaed. I don't have my binder with me, but what I want to do is this afternoon email the state and let them know exactly what I found. But I think there's two different institutions that need to be subpoenaed.
All right, Norma, recall this at the beginning of November. States you need to have that turned over to him by then, and you need to be prepared to tender an offer.
Yes, Your Honor.
All right, November 6th. All right, thank you.
Thank you.
Thank you for addressing appropriate for court. Thank you. Israel Gonzalez. All right, so where are we on discovery?
Oh, on discovery in this case, I believe I have everything. I have to recheck again because every time they add something, I have to update, but I believe I do have the majority of it.
All right, and was an offer tendered?
Not yet, Your Honor. And the reason being, my client has two cases that are pending, that you know, I'm sure. And so one doesn't want to know what to do with because of the other offense.
All right, and are you on that case as well?
Yes, ma'am.
All right, Ms. Ferguson, I need a 30-day reset. State at this time you'll need to be prepared to tender an offer.
Yes, Judge.
We'll be back on November 20th. Once you sign the reset form, you are excused.
Your Honor, I have one more issue.
Yes.
If I may, I filed it in the wrong, because I thought it was pre-indictment. My client's been on a GPS monitor and partial house arrest since, well, it was a full arrest since May when he got arrested, then we changed it to partial. And so it's been about 6 months, and we were asking for him to have the GPS monitor removed and the status of the partial house arrest removed.
All right, if you will speak with Ms. Ferguson about putting that on the docket, and I'll hear it, and your client can appear by Zoom.
Okay, because I'll have to file it in the right court anyway.
Okay, all right, thank you.
Your Honor.
You're welcome. Brandon Lee Villarreal. Yes, I mean.
Jonathan Ross for the defense is the first setting on new indictment. I believe we, if we could get a brief reset, Your Honor, we'd appreciate that. 30 days should be fine.
All right, Ms. Ferguson, recall this for Thursday. All right, we'll see you all on Thursday. Francisco De La Rosa. Good morning. Thank you for dressing appropriately for court. All right, so today is plea deadline date.
Yes, Your Honor, and we do have a plea offer, and although there still looks like there's some room for us to discuss that some more, would the court consider another plea deadline?
I'll recall you back for Thursday.
Okay, I'll talk to my client about it, Judge.
All right, Ms. Ferguson, recall this for Thursday for disposition. Nalani Desmith. Yes.
Judge, we're here asking for the bond to be set on these cases. Apparently an affidavit of surety to surrender was granted.
All right, has a request for bond been
I
filed?
filed, they were e-filed this morning, Judge.
All right, once I have those, I'll take
They've
it up.
they've been accepted.
No, I said, once I have them, I'll take it up. I don't have it. All right, Johnny Richard Gonzalez. Oh, what happened? Why is he in custody? Has he always been in custody? Oh, okay. I'm telling you, see, he was dressed so appropriate for trial. I didn't notice anything else. All right, we're back on the record in 2025 CR 010295, State versus Johnny Gonzalez. See, I don't know where that status is coming from. And counsel, this is an application for deferred adjudication and community supervision.
Yes, ma'am.
And state, are you proceeding on the indictment as presented?
Judge, we're waiving the punishment enhancements.
Any objection?
No objections.
And Mr. Gonzalez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And count one, your charge is possession of a controlled substance penalty group 1 to 4 grams. And count 2, you're charged with unlawful possession of a firearm by a felon. Those are third-degree felonies. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine in each count. Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Did you understand if you're not a U.S. citizen, by entering into a plea bargain agreement in either one of these counts, you will be deported, denied naturalization, and re-entry into the United States?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 1 and 2. Punishment is to be assessed at a cap of 8 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication or community supervision. They're taking in consideration 2025 CR 013223. There's to be restitution of $180 to DPS and AUS 2502025545. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, I do.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
To count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
Count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence?
State offer states 1 in attachments.
Any objections?
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of counts 1 and count 2. The court will defer finding of guilt as you applied for deferred adjudication. Counsel, if you would like, we could set this for a PSI. It'll probably be 8 to 12 weeks. Or if you would want your client back sooner, we can have him back sooner, and you can present whatever evidence you wish to present to the court.
Yes, Your Honor, you absolutely will. I did want to put, and this is not part of.
Well,
the
does he
agreement.
want to waive the PSI or does he want a
He
PSI?
wants, go ahead, waive the PSI.
Yes, yes, Your Honor, I wanted to waive the PSI.
All right, so then what will end up happening if I'll reset this at a date your attorney deems appropriate for him to have witnesses or whatever evidence he wants to present to the court. Do you understand?
Yes.
And state, do you have any objection to the waiver of the PSI?
No, Your Honor.
All right, so Counsel, when would you like this recalled?
Couple of weeks, Your Honor.
All right, Ms. Ferguson, I need a 2-week reset.
We'll
All
be
right.
ready in 2 weeks.
All right, is there anything else?
Nothing, Your Honor.
All right, so we'll bring you back on November 4th. At that time, I'll hear whatever evidence is presented and make a decision on your application.
Thank you, Your Honor.
All right, thank you.
Yeah.
All right, the parties on Nalani Desmith or Desmith. All right, and Yaya, are you able to pull on this one, the reason the bondsman is no longer on the bond?
Yes.
All right.
Your Honor, I do have that pulled up.
Oh, awesome.
It appears that she failed to comply with the rules and regulations by failing to report to surety weekly and not having contact.
All right, the court is calling 2024 PF 10920, 2024 PF 10921, CM 120243, State versus Nalani Desmith. Desmith. Could I have parties announce?
Ashley Jones for the state.
Christopher Sentence for the defense.
And are you Miss Desmith? You're gonna have to speak up.
Yes, ma'am.
All right, so defense has filed motions seeking a bond in each of these cause numbers.
Yes.
State, are you ready to proceed on the motions?
Your Honor, I actually just came across some new information. May we step back for just a moment?
Yes.
Thank you, Judge.
Felix Beltran. So counsel, let me see. Where are we on this case?
Judge, he's rejecting the plea offer.
All right, so he wants a jury trial?
If we have to, yes.
All right, so is this family violence or criminal trial division? All right, we'll bring you back at 1:30, but I will tell you, family violence is up first.
Okay.
All right, we'll see you back at 1:30.
Yes, ma'am.
We're back on the record in 2024 PF 10920 and 2024 PF 10921 and CM 120243. If y'all could re-announce for the record, please.
Ashley Jones for the state.
Christopher Sentence for the defense.
And are you Miss Desmith?
Yes, ma'am.
All right, so state, are you prepared to proceed on the motions?
We are, Your Honor.
And have you all reached an agreement?
Yes, Your Honor.
And what is the agreement in the cause number ending in 20?
The PF cost number, Your Honor?
Yes.
It's gonna be on all of the cases, just so the court is aware, it's just a reinstatement of the original bond and conditions.
All right, so I need to know the bond
And
amount.
yes, Your Honor, I just wanted to put that on the record. For 20, the bond amount is 12,000.
Okay.
And let me get the conditions, Your Honor. It's going to be a no contact order with the victims in this case, which are children. Victoria Alwyn.
So what I can tell you is the court is going to change conditions a little bit. So if there's to be no contact with specific, children, there should be a no contact with minors, period. You understand? And I'm not going to allow you to reside in any household with minors. Do you understand?
Okay, even though Child Protective Services has closed their case and had no recommendations whatsoever?
Well, sometimes Child Protective Services will close their case. And my standards are sort of different.
No, I
And what I can tell you is I don't have before me anything about Child Protective Services. So if your attorney comes back and he wants these conditions amended, I always keep an open mind, but I will need to see things from Child Protective Services and exactly what they did, Because sometimes what Child Protective Services will do, if someone who they think is a danger to a child gets taken into custody at the jail, they're like, oh, we're going to close our case because the harm has, the potential for harm has been removed because that person is in custody. Then when that person's out of custody, things just go back and nothing has been done. So I need more information if I'm going to do that. Okay. All right.
And the second child, Your Honor, is going to be Forrest Alwyn, and it does say unless supervised. That's the original condition. I understand the court's ruling.
I'm doing no contact with
Yeah.
minors.
No alcohol consumption and no firearms.
So I can't see my children at all, Your Honor.
Your attorney, once your attorney can come back. And this is what I'm going to tell you. I don't know enough. Now, what I can do is this case can be reset if your attorney wants to bring it later in the week and bring me the information with CPS and have the caseworker zoom in. Then I can take up this entire matter and set your conditions at that time. Or I can set your bond now. But for now, it's going to be no contact with minors. So if you let me know what you want me to do. Do you want to have this reset? And he can have it reset. He can bring it back on Thursday.
How quickly, if I bond out now, how quickly will you be able to get the paperwork to the?
I just get it to me and I can.
Because you have that and the advocacy paperwork already showing.
At the CPS.
Okay.
So do y'all want to just come back on Thursday?
Can you please bond me out so I can make sure he has everything that he needs to get?
Well, I mean, I'm not in charge of bonding you out. Somebody, the only thing I'm here,
I think what she's asking for is to set a bond today.
oh, I'll set a bond today.
Please, and that way I can get everything that you need together.
Sure. All right. And can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give to help you God? All right, you can lower your hand, state your name for the record.
Neilani Brienne D. Smith.
I'm sorry, what?
Neilani Brienne D. Smith.
Okay. Can you tell me, in the past, have you ever had any type of mental health diagnosis? All right. In the past, any type of drug use?
No, ma'am.
All right, then. What we'll do, and you said the bond is 12,000 in each case?
It is, Your Honor. And just so the court knows, some quick facts of the case on the PF cases, it does look like there was a lot of drinking involved that night. It does also look like some substances were found in the defendant's purse upon when the police started investigating. However, those substances were not able to be tested and have not been tested. So I just want to put that on the record.
All right.
And also there was a rape kit done that night, Your Honor, for a rape case that's still open because there was evidence of.
Well, I will tell you this, you may not want to talk about what you think the facts are in the case or what the facts are until you discuss it with your attorney, okay? All right, so this is what the court is going to do. In each cause number, the court will set your bond at $12,000. In each cause number, there's to be no contact with minors. There's to be no alcohol and no firearms. There's to be random UAs, and the court will order that the fees are waived. And counsel, if you want to speak with the coordinator about getting a reset for the court to perhaps alternate amend
We'll
conditions.
do that as soon as I'm in receipt of the paperwork.
All
to
right.
do that. And on the CM case, Judge, I believe the original bond was $3,500.
That is correct, Your Honor.
Okay, then. And on the CM case, your bond will be set. And for the court reporter, that's CM 120243. Your bond will be set at, what's the amount, counsel?
3,500, Your Honor.
That will be set at 3,500 with the same conditions as in the other cause numbers. All right, we can go off the record. So what I can tell you, the court will reconsider things, but what I need is I'll need that information from your attorney before I can do so.
Thanks.
Because part of my job is to make sure that the community is safe when I set bond. And, and children are part of the community. So once I receive that, then I'll reconsider things, okay? But you need to make sure you get that from your attorney. And attorney, this is what I need. Either I need those documents from, well, not either. I'm going to need the documents to review and just have the caseworker let them know they can zoom in. All right, thank you. And it'll be set whenever your attorney sets it.
Okay.
All right, so state,
Yes, Judge.
he's saying he doesn't have a video.
Judge, so they were just turned over this past weekend, so I believe that he had access to them starting yesterday, but there are some that are too big for him to view, so we've conferred about that for me to put them on a drive for him. He provided me with that drive today. But they have been tendered to the state just this week, this past weekend.
Just 1 second. So when will all of this be accomplished?
It should be, yeah, so I'm gonna work on, after we do jury selection today, I will work on getting and extracting the videos for him and provide them. He's just across the hall, so I'll get them to him as soon as I can. And then from there, a couple of weeks, I believe. 2 weeks.
All right, Norma. Put this for contested on November 18th. Sure.
Yeah, I'll give it to her.
All right, thank you.
And I have a question, not asking for an advisory opinion, but just a hypothetical. And I'd give Ms. Galloway a heads up that I'd be asking. Because I know every court handles these things a little differently. If someone were to say, enter into an agreement that calls for confinement, but they wanted to get some affairs in order, namely with their personal business, does the court accommodate that?
No.
Okay.
And just 1 second. Gary, are you gone? All right, today is your plea deadline date. Have you all reached an agreement or no?
We have not, Your Honor.
All right, Ms. Ferguson, need a jury trial dates. And this is a 2-day trial.
And Your Honor, may I interject just one thing? We are gonna file a motion to suppress. I don't know how this court runs it.
Is it dispositive?
It would be dispositive, Your Honor.
All right, when will you be ready for a motion to suppress?
Whenever, Judge, I would just kindly ask that we don't set it for the 28th.
Okay. So what date do you all want it on?
Any other date next week or the week after is fine with me, Judge.
So y'all want to confer on a date?
Same date.
I tell you to confer on the date. That would not be a good date because that's jury trial date. So it would have to be on a Monday or Tuesday. Is that correct, Norma?
November 4th.
All right, then we're gonna come back on November 4th. You'll need to do a jury waiver. All right, David Cortez, if you'll come down, you need the cause number? It's DC 219 CR 6016.
Thank you, Your Honor.
All right, so your attorney still hasn't shown today. As you're aware, you were here yesterday and we were waiting for your attorney. And he's still not here. So what we will do is we will call you back for Thursday and we will see if your attorney appears. This is the attorney that you hired or your family hired for you. So all we can do is reset it.
I wanted to say something.
Okay.
When I hired an attorney, when my problem occurred, it was 2019.
All right, so here's the thing. I don't suggest you talk to me about anything that you presume to be the facts of your case. What I can do is I can have someone from MAC come down. Norma, call MAC to come down, please. And they can speak to you.
Okay.
And you can address things with them. It's just best that I not hear any of that or that you not speak to anyone before you speak with your attorney. I believe when you were magistrated, you were probably informed of your rights. And one of those rights is that anything that you say can or may be used against you in any criminal proceeding.
Okay, perfect.
All right, so if you'll wait here, we're gonna have someone from Managed Assigned Counsel to come. Maybe they can get in touch with your attorney. If not, then we're gonna bring you back on Thursday. Okay. Thank you.
Yeah, do you want me to wait until?
How long before they come on?
It's good, that's.
Okay, all right, they're on their way. Thank you so much. Anyone else ready? Kimberly Cuevas. Court is calling 2025 CR 008801. State versus Kimberly Cuevas. Could I have parties announced?
Rick Pena for the state of Texas. Jorge Canales from Ms. Cuevas.
And are you Ms. Cuevas?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
I have, and I have.
Court will find that the state is in compliance with discovery. Ms. Cuevas, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
How?
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, yeah.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Ms. Cuevas, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with injury to a child, elderly, or disabled person, bodily injury as a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Cuevas, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, no,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 2025 PF 09696. There's an affirmative finding of family violence. There's been no contact with Evelyn Reyna and Robert Reyna. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? All right, do you want to discuss that with your client?
Yes, Your Honor. Your Honor, my client is going through a divorce proceeding. And she was trying to get primary custody of her child. And I believe
Both my kids.
with both children,
Oh, I have nothing to do with what they do on the civil side.
it has to be addressed in the civil side.
So I won't be able to have sole custody, I can.
So here's the thing, I don't know what they will do with your case on the civil side. All I can tell you is legally, with an affirmative finding of family violence, we can go off the record. Here's the thing, if there's a custody issue that's going on the civil side, if opposing counsel sees somebody has an affirmative finding of family violence, that makes their case easier, depending on what's going on. What I can tell you is all things equal, If one person has an affirmative finding of family violence and the other person doesn't, then the court is supposed to take note of that. And that person who has the affirmative finding of family violence, they're not supposed to be designated as primary custodial parent. You want to discuss it with
Yes,
your
ma'am.
attorney? All right, I'll have y'all sit back. Brian Moreno.
Afternoon, Judge.
Hello. So,
Judge, I believe this is like our second appearance.
yes, because he has a new case that hasn't been indicted.
Judge, I believe it was just recently indicted.
Okay,
Yeah, so Judge, I'm looking at discovery right now and we've been given an offer. I'm telling my client, we're not taking anything until I have a chance to look at everything I need to, so.
understandable.
Yeah.
Norma, if I can have a reset for 30 days. November what? All right, November 20th. And that will be final discovery.
Yes, Judge.
I'll see if school records come available.
All right. Oh, they should be. You know, every child who was walking home to turn their report card in, their parents, it seems like they always were able to do that.
Number 24.
All right.
Okay.
No,
Judge.
she said November 20th.
Yeah.
Okay, all right, thank you.
You got it. All right, so November 20th.
All right, state. Court is calling 2025 CR 010371 State versus Cherry Michelle McKinley for the state.
Megan Galloway.
All right, this hearing was scheduled at 9 a.m. The defendant has not made an appearance. It is now 2:10 p.m. Defense attorney appeared at approximately 11:45. The defense attorney has not returned. Any request, state?
What's the judge's warrant?
All right, the court will issue a judge's warrant, remain without bond. If the defendant makes an appearance, the court will reconsider. Adrian Garcia.
Yes.
Come down. All right, where are we on discovery?
I think the next setting is discovery setting, right?
No, where are we on discovery today?
Well, I have discovered.
I've disclosed what we have to defense, it's available.
All right, so has an offer been tendered?
Pretend get.
All right, Ms. Ferguson, set this in 30 days for a plea deadline date, please. All right, you'll be back on November 20th. On that date, you need to let the court know whether or not you've reached an agreement with the state. If you have not reached an agreement, your next court date will be a jury trial date. Thank you.
Thank you.
You're welcome. Have a good day.
November 20th?
Yes. All right, Vashawn, do you know why James Edward Kellogg is on the docket? Is there a motion to revoke?
Yes, Judge.
All right. Norma, recall that for Thursday.
All right.
All right, who are the other people who are in the box?
Rogelio Favela.
Which page is he on? All right, his case was reset for October 27th. Yes, October 27th. And who else is over there?
Mr. Kellogg.
All right, Mr. Kellogg, you're coming back on Thursday. And Mr. Favela, your attorney asked that your case be moved. He's in trial. So we're gonna recall him back.
He stated to me the attorney has not shown up 4 times.
I don't know if it's 4 times or not, but I was gonna recall this case for Thursday. And then maybe someone can get in touch with his attorney.
Yes, I will. And if there's some issue, then I'll be back and we can get another attorney. appointed.
Well, no, his attorney is retained, so.
Oh.
Yes.
Oh, cause he was, okay. I don't want him anymore.
No, I'm sorry. I can't address those issues. Your attorney will need to be here. I just brought managed to sign counsel down, so maybe they can get in touch with
Oh,
the
okay.
attorney for you.
Okay, he told me he had an appointment.
No. He was retained.
I can try to reach out to him.
Okay. All right. So we're going to recall this back on the 23rd,
At 9 o'clock or 1:30?
9. All right. Thank you.
My pleasure.
Thank you. Bye-bye. All right. The court is back on the record in 2025 CR 008801, State versus Kimberly Cuevas. All right. And Ms. Cuevas, where we stopped, the court was giving you the consequences of an affirmative finding of family violence. And it appeared you need to discuss that with your attorney. Have you had a chance to discuss that with your attorney?
Yes, sir.
All right. And counsel, does she have a civil attorney?
She does.
Does she need to discuss this with her civil attorney before we continue?
I would like to, but I don't think that I'd get a hold of him right away.
Well, what we can do, if there's no objections, we can recall this for Thursday.
Okay, yes, I'd like to talk to him.
All right, we'll bring you back on Thursday. Okay? Once you sign the reset form, you're excused. You're welcome. Counsel, are you ready on Mr. Beltran?
Yes.
All right, Mr. Beltran, come up. So what would you all like to do?
We'd like to proceed another day, Judge.
Okay. All right. And so what I can tell you, Mr. Beltran, it appears that there was some then put in the system by somebody else. So your attorney is not going to be charged with, well, I should say, you all will not be charged with the motion for continuance. State, do you have any objection to proceeding on a different day?
Judge, I'm not gonna like formally object, but I just want all parties to be aware because earlier today, the plea bargain was rejected. And so the named complainant in this case had a surgery that was set for tomorrow that he had to reschedule to be here to testify. And so I just want everyone to be aware of that.
Well, we were never set for trial, Judge, so I don't know how that should have affected him in the first place. He should have never even been notified.
All right. So this is what we'll do. State, we're going to recall this for Thursday. It's not for a jury trial setting. It's just for you to get a chance to speak with the complainant and find out what is the day that they'll be available, unless the defense is in agreement to them testifying by Zoom.
No, Judge, and
Okay.
that brings up the issue of more discovery. He hasn't even finished his medical treatment. How are we having to face a trial on punishment? If there's a finding of guilt, we don't even know what his condition is. He hasn't even had his surgery yet. Getting way ahead of ourselves.
So, no, I don't think so. So this is what we'll do. We're going to recall this for Thursday. Will that give you enough time to speak to your complainant about when? All right. So we'll come back on Thursday.
Yes, ma'am.
All right. Thank you.